The next topic of discussion is based on this news article, where Supreme Court has set up a special investigation team, that is SIT, comprising 3 senior IPS officers, women IPS officers, to investigate an alleged rape of 3-year-old child in Gurugram. So, what was the case? Actually, the case was registered in the month of February, where it was alleged that a child who was 3-year-old was repeatedly sexually assaulted by 2 women domestic help and their unidentified male accomplice. Now, Supreme Court has said that Supreme Court has described the handling of the case by Gurugram Police and Child Welfare Committee as shameful and insensitive. Now, important from the perspective of GS Paper 2, that is social justice, the mechanism laws constituted for protection and betterment of these vulnerable sections. So, what we will be covering? We will be covering background of POCSO Act, and we will be covering the salient features, we will be covering challenges and way forward. So, let us begin the discussion. Now, the background of POCSO Act starts way before 2012 when it came into picture. The act came into picture in 2012. Before that, there was no separate law. There was no separate law to deal with child sexual abuse. So, how it was being dealt? It was being dealt through various sections of IPC. Then what was the problem? Problem was that IPC sections were fragmented and gender specific, mainly focusing on female. So, let's say section 354, in many cases it was invoked. It is related to assault on women with an intention to harm the modesty of women. Section 375 was there, IPC section 375, which defines rape, again for women. So, these were not able to address the problem of penetrative and non-penetrative assault, or you can say crime against the child, and they were not child specific. This was the scenario before 2012, and many law commission have opined for a specific law. So, like 42nd Law Commission report said that we should be including dedicated provisions in IPC itself, because there was no idea of this act altogether. So, they said that IPC should have dedicated provision. 172nd report said that we should be amending IPC sections so that we can have specific provisions for the child sexual abuse. Accordingly, after all these debates and issues, in 2007, Ministry of Women and Child Development, they conducted a study, a survey, and they found that over 50% of children have faced some or other kind of sexual abuse. And this was alarming. Based on these findings, government brought in the Protection of Children from Sexual Offence, that is POCSO Act 2012. Another reason was the international obligation or commitment. India is signatory to UN Convention on the Rights of the Child, that is UNCRC. So, the necessity to brought in a specific law to protect children from sexual abuse was felt and was brought in the year 2012. Now, the key feature includes the first thing, as is the case with the sexual assault, the privacy, or you can say even media and courts have been instructed or barred from giving the name or identity of the you can say victim. So, first thing is maintaining the privacy of the victim, so that they should not face the unnecessary scrutiny or burden, or you can say pressure from the outside world. Then it was having comprehensive coverage. So, it addresses various sexual offences against children, including assault, harassment and pornography. So it was covering all. So it gave in detail the definition of all these offenses and covered them all, which was the need of our. Earlier it was basically whatever the laws were for women, that is in the section of IPC, that were being implied on the sexual assault on children also, especially in case of if child is female child or girl child. Then it was made gender neutral, so that any child which is under the age of 18 should be given protection under the POCSO Act of 2012. Earlier it was not gender neutral, it was protecting female or girl child. Now it was made specifically gender neutral. So even a male child will be protected under this act. Now child-friendly procedures were ensured, so that investigation and trial, during investigation and trial, children or the victim should not be harassed or being put into unnecessary pressures. Then the provision of mandatory reporting. Now this is very important because it requires any person aware of child sexual abuse to report it. So let's say if you are a doctor or a teacher or a person who is, let's say you are a coach, and a child shares with you the incidents of sexual abuse done by anyone in the family, outside the family, anyone. Now it is mandatory on your part to report that abuse. Otherwise, there is provision of punishment if you are withholding this information. That is what mandatory reporting means. So it is not just parents of the child, but anyone who is aware of the situation can complain about the child sexual abuse. Then special courts to deal with the issues. So a special court should be designated so that these issues will be dealt with specialized knowledge in a swift manner and sensitive manner. Plus support services. It also provides for medical, legal and emergency assistance to victim during the trial and after the trial. Then comes strict penalties. Definitely it acts as a deterrent, so was the case here. So earlier it was 7 years, but now in 2019 amendment, the imprisonment was raised to 10 years. Now if the penetrative offense is repeated, is aggravated, it is 20 years, and even if it has caused the death of victim, court can consider the death penalty also after the amendment of 2019. But as has been the case with most of the thing, POCSO Act also has various challenges. As you can see, Supreme Court has flagged the misuse of POCSO Act, that it has been weaponized to kind of penalize someone who a person or a family doesn't like. Or here again you can see that Madras High Court has stated that young boys in consensual relationship often bear brunt of POCSO. So these are the issues. Apart from that, there are other issues related to POCSO Act. We will cover that also. First is the conviction rate. Now NCRB data shows that registration of offenses has increased. Okay, so you can see here in data from 2019 till 2025. If you will see the registration of the cases, it has gone past 1 lakh, and disposal rate has also increased. That is a good thing, that you are registering case, people are coming forward to register cases, and courts are disposing them at a faster pace. But problem is the conviction rate is going down. So it was in 2019 it was around 34-35%, but now it is around 19%. What does that mean? There are two meanings to it. First, conviction rate is going down, that means investigation has not been done properly. That is why the offenders are not being convicted, or their offense were not being proved. Second possibility is that there are cases which are fake, or having no proof, or just being misused. The act has been misused to penalize someone who you have enmity. So both possibilities are there, but ultimately the main thing is that, okay, there are false cases, but not to a level that conviction rate goes down by half. So earlier it was 35, now it is 19. So almost half is the conviction rate. So it is showing a much much bigger problem, that is the investigation is not being done properly. Second, the criminalization of consensual adolescent relationship. Now the problem with POCSO Act is it has delineated various crimes, it has delineated various offense, but it has an umbrella definition. Any offense that has been done against any children will be considered as a criminal offense. Now there are, because in teenage many people are there in a consensual relationship. Now if complaint is filed, as you can see, as you can understand that why Supreme Court and Madras High Court is saying that they have weaponized, families have weaponized this act to prosecute someone who they don't like or who they have problem with. So what is happening, even in consensual relationship, if family is not agreeing, they will put a POCSO Act case. So there is no differentiation between the definition between what is consensual and what is not. That is again a problem. Then comes the implementation gap. So acts asked for recognition or appointment of a special court, designation of a special court, but many states are lagging. Even if they are not lagging, the pendency is very high. As you can see, here is the data of various states, again a data from NCRB, which highlights how many cases are pending. More than 1 lakh cases are pending in various states. If you will combine them, more than 1 lakh cases are pending. So defeating the very concept of a speedy and timely trial. Then comes lack of trained personnel, as has been highlighted in the headline itself, that it is shameful and insensitive, because there are many stakeholders, and this experience of a victim who is facing some untrained personnel, some insensitive questioning or insensitive behavior may affect the overall psychology of a child. Then comes the social stigma and underreporting. Just recall the mandatory provision. Now many people, this mandatory provision has become counterproductive. Why? Because let's say if someone is a medical professional, a child shares his or her trauma with him or her. So with that medical professional now lies the responsibility to notify the authority that this child is sexually assaulted or molested. Now with this mandatory provision, these people are many people, they don't want to get into legal procedures. So this is proving to be counterproductive. They are underreporting, just because who will go into the police and court, who will face this shame, and who will face the scrutiny of the society. So this mandatory provision is proving counterproductive, and people are hiding the information just in a want that they don't want to get into trouble of others. Then comes another thing is, let's say if a child is sharing the problem with someone, there is confidentiality, because they trust you, they believe you, and now you have complained. Now this trust is gone, and we are talking about a child mind, and then in future course of action they will not be sharing anything. So both from the victim perspective and from perspective of a person who is supposed to report, this particular rule, or you can say provision, is proving counterproductive. Next come the digital threats. Now digital threats like online grooming, where an adult connects with a child and eventually they trap them, they kind of brainwash them into with an intention to have sexual gains. And child pornography. Now digital arena is something where most of the laws of our land are lacking, because there is one umbrella law, IT Act, and we are dealing everything through that lens only. So again, the technological adaptability of the law is missing. Then compensation. So compensation provision is there, but it is very complex and very lengthy. So interim compensation during the trial and the final compensation, both are very complex, and often in most of the cases they are found delayed or inadequate. So lastly, as the case with many of the laws in India, there is lack of awareness. Now many studies have highlighted that only 30 to 35% of population is aware about presence and provision of POCSO Act. So what could be the possible way forward? First thing is the context sensitive application. So you need to differentiate between the exploitative abuse and consensual adolescent relationship. So you need to avoid over criminalization. Second thing, that institutional capacity has to be improved. That is, number of special courts, fast track mechanism, police personnel, prosecutor and judicial members of judiciary should be sensitized. Then victim centric approach should be there. So psychological counseling, eyewitness protection, and develop the child friendly infrastructure should be developed. Apart from that, we need to provide awareness and social change through the urban local bodies, through schools. We can utilize parent teacher meet, we can utilize some clubs, we can utilize some NGOs, so that awareness should be improved. Then the cyber crime, issue of cyber crime. So we need to increase the surveillance, strengthen the digital surveillance, and we need to improve the coordination with IT laws and enforcement agencies. Now most importantly, to improve the conviction rate, it is required to back the investigation with forensic support. The scientific forensic reports and methodologies of investigation will help in improving the conviction rate. Now based on this, this is your practice question, that the POCSO Act marks a shift towards a child-centric justice system, yet implementation gaps persist. Analyze. 15 marker to 50 word answer. Try to write it to assess your understanding.